Hello, everyone. Welcome in.
Hello, everyone. Thank you so much for being here. We're going to get started. I know we're like a minute or so early, but we're so excited for this talk today because I have been working with businesses in every industry over the last 3 years, trying to help them successfully adopt AI into their businesses. And the questions I get around what are we allowed to do? What are our usage terms? What are we legally allowed to input into these platforms? What do they do with our data? Do I own what comes out when it gives me an answer, it gives me an idea for a product or a business or a contract or anything like, do I even own that stuff? And so today we have Andrew Degner, and he's with Lattice Legal. He's a business and contracts attorney. I could not think of anyone better to help us cover this territory. And Andrew and I did a run through of this a couple of days ago, and I learned a ton. I know you're going to learn a ton. And so we're super excited to dive in here. And so, by the way, oh, here, I got it. So I can control the slides here. So this is called What Did You Actually Agree to? The AI terms of service myths, fine print, and the things that may surprise you. I think everyone's going to learn something really valuable here today. So I am Rob Wiltsey. I'm the founder of Future Foundations AI. Essentially, we help small and mid-sized businesses adopt AI successfully by finding the bottlenecks in their system first and foremost, and then looking at the available AI technology and having really thoughtful recommendations about here's how you should be using AI in your operations to actually improve your outcomes of your business. And we build those automations once we identify them. So we actually build custom agents and automations, and then we also train your team. We train the humans in your company to use AI and feel empowered by AI because it's very exciting and it can do so many wonderful things. And I will let Andrew introduce himself.
Hi, everyone. Andrew Degner of Lattice Legal. I've worked in big law firms. I've worked in-house at Microsoft, Mattel, WPRO, some big organizations, seen a little bit of everything. And these days work as a fractional general counsel, business and contracts attorney to help businesses navigate things like AI, major product rollouts and implementations, and a lot of SaaS vendor agreements, you name it. And AI definitely is one of the things putting a lot of pressure on business teams these days, both to navigate the terms, figure out how to implement, how to put in policies. And, if you don't have a lawyer you can call to ask questions about this kind of stuff, that's what I'm here for.
And Andrew is who I call when I have those kinds of questions. And so super excited for today. So here's what we're going to cover, and we have a lot of ground to cover, and so we want to leave as much time for Q&A at the end. And so we're going to start with common misconceptions. These are the most common misconceptions that Andrew and I have seen working with businesses around their AI usage terms and what they think they're allowed to do and what they think is compliant. And so we're going to move into some details that may surprise you that are in these terms. That you may not read because these terms are not always the easiest to understand, although they are trying to make them more easy. But I don't think all of us read those terms. I think we're all a little bit busy, and so that's why we're so thankful to have Andrew here. We're gonna walk through then very plainly like what the terms say and what they lay out by platform. And as we're going to be talking about, there are many different levels and tiers of these services. So like if you're using ChatGPT, the free chatbot version, that has different usage terms than the enterprise plans and then the API terms if you're using the API side. And so there's a lot of different levels to that. So we're going to go through that one by one, so everyone's going to have clarity around that. And then this was a great section I'm excited about, is where businesses often get burned. So we're going to talk about some use cases that maybe you've done. I might have done some of these, and they are actually pretty risky to do with AI. And so you're going to want to know about those. And then we're going to talk about your action plan. So for everyone on this call, what we recommend you do next in your organization and your life as a professional to make sure that you are navigating these things well. And so let's dive into common misconceptions. So Andrew, tell us the first area that businesses can get in trouble with their usage of AI here.
Yeah, so the most common thing I think a lot of folks are dealing with are just, if I pay for it, my data is private and I'm protected, that kind of core, free is bad, right? I think we all have sort of come to the understanding that, if you're not paying for it, you are the product, and we kind of get that stage. Especially in AI, this is true of a lot of SaaS services. There still is a big divide once you start paying for it. The way the current regime of most of the large AI platforms, to the extent the service you're dealing with has multiple tiers, and always be careful if it doesn't. That usually means it's kind of at the lowest end. The distinction is typically between enterprise and the paid plans. So you'll see as we talk through some of this and show a little bit later, just starting to pay, you're still on the same terms as free. It may add a few elements. It's typically service improvements, not privacy, confidentiality. That those terms are typically only on the enterprise terms. This is true across Anthropic, Google, Microsoft. All of these core platforms have the same kind of structure, and they're homogenizing a little bit, which at least makes it a bit easier. But you want to be careful because AI training is typically the first thing that will change once you start paying. That may default to off. It may not. It depends on the platform. But you're still not getting confidentiality typically until you're on enterprise. You're typically not getting any robust, disclosure about what's happening with your data until you're on enterprise.
I think that's so important because some people think, oh, I was on a free version. Now I'm paying, 10 or 20 bucks a month. So I must be getting some, improvements in my terms, but that's not necessarily the case. It sounds like some paid plans provide increase, privacy. They don't train the models on your data and things like that, but not all paid plans. And so you have to be aware of like where you are on that. And also, and we're going to talk about this more, but these terms don't even stay the same over time. So you actually have to be constantly looking at the tier that you're on, and are the terms still the same as the day that I signed up, right? And so this is a really important one. So talk about copyright and ownership of the things you create using these AI tools.
Sure. So, most people, I think when they're thinking about sort of ownership and intellectual property, they're thinking about copyright. There's obviously both patent and trademark that operate in different spheres and can sort of overlap on the same intellectual property. But, the core, it happens instantly. You don't have to formally file for it. The minute you fix something in a tangible work, it is now yours. And if somebody else tries to copy and steal it, you can prevent them from doing so. That's one of the most fundamental U.S. intellectual property rights. One of the things that can be a little bit misleading about the way that these platform terms operate and the current state of the law with regard to AI and intellectual property ownership is most of the platforms will say either you own it or we don't own it. They'll just say, hey, we're not trying to own it. To the extent it's ownable, it's yours. And that, when they sort of say to the extent part, that's kind of a clue of like where the state of the law is. The most current law says that this goes back to sort of the principles of intellectual property in the US, that it's to encourage human innovation, and there has to be a human input element more so than just the prompt in order to secure that. The most recent cases before the US Copyright Office, this Thaler v. Perlmutter is one of the several cases right now that the Supreme Court refused to overturn, stated that without meaningful human creative contribution, it's not copyrightable. If you put in a 5-page long, super detailed prompt that you worked on for years, that prompt itself may be copyrightable in a sense, but the output that's coming out of that, if you do not touch it further, is not protectable. And that doesn't mean that it can't be used. It sort of means the opposite. It's akin to things in the public domain. What's coming out is not capable of copyright protection. It may still be capable of trademark protection if it gets associated with a brand and sort of arises to that level. But the fundamental copyright protections don't attach. So you're sort of generating public domain content in a sense. And you also have the mixture of the inputs that model was trained on and how those things are coming out, which we'll speak to a little bit later on a bit further. But it's important to kind of think about the fact that you own it may not mean that you can protect it or sue others to stop them from using it. There's a distinction between ownership and copyright protection and how that plays in. And so, when a lot of people read or see on the terms, hey, we don't own it or you own it, that's usually where they kind of stop analyzing. And this is a clue that, you need to think a little bit deeper about what the ramifications that are, especially for creative works, things that, you are putting out there and do have a lot more opportunity for human, editing and restyling in combination to then make it something that is protectable.
That's so interesting, and this is one of the things that I learned when we were doing this, just kind of this run through for this webinar, was that the degree to which it's, if I understood correctly, it's like the degree to which it's copyrightable is the degree to which there was human input from you, and less, if you just type in, hey, design a product for me, and it's just like a very short, open-ended question, and you get something back out of it. You're saying that might fall into like public domain because it just came from the model. Do I have that right?
In a sense. So, what the Copyright Office specifically said here is that the complexity of the prompt is not a key factor. It's really what happens sort of after with the output, that the thing that the AI is putting forward, especially because of the way AIs function, and they're sort of, generating typically an entirely different thing than what you were instructing, right? You're putting in words and getting out a video or a picture or something, right? That without further human intervention, if the only thing you're doing after that is posting it, you've not meaningfully contributed to the output work in that format. That makes it difficult for the Copyright Office right now is saying we're not issuing a copyright for that. So it's unprotected in the copyright sense.
Yeah, and Gary asked a more pointed version of my question, which is like, what constitutes meaningful human creative contribution, and does it come down to kind of a subjective interpretation?
It's not a bright line, and there isn't like a do this one thing and now it's it's a little, when you see it a bit with the law right now, this is obviously developing. There's a lot of applications and further lawsuits kind of flowing through. We're still at the early legal stages of a lot of this, so there hasn't been a strict definition, and likely will not. The way that this functions is true of a lot of intellectual property law. There are rough boundaries, and that's somewhat by design. We don't want it to be so rigid that you're not able to get new IP in it. The way that the Copyright Office tends to view these things, their instructions are somewhat general guidelines. So I think my advice for a lot of folks is a little bit of your own gut check. Like, if it feels like you didn't do a whole lot, then it's probably high risk that it's not going to be copyrightable. If it feels like, well, sure, I got this initial image, but then I put it in Photoshop, I added a bunch of other layers, I used some of my other art and collage that in, or then I edited a lot further, and this was inspiration, but it wasn't the final project. I think we all get the sense that's a lot different.
Yeah, like you kind of know in your heart whether whether it's copyrightable. This is a great one. So let's move on to vendor liability. So if AI tells you something that is erroneous, or if it tells you something that causes you to take an action that causes damage to you, like, is AI liable for any of that stuff, or how does any of this work?
Yeah, I mean, hopefully the intuition of most folks here is that they don't believe this misconception quite as strongly as maybe some of the others. I think the somewhat obvious answer is, yeah, these companies are not going to be on the hook if it gives you bogus answers. There's a lot of warnings in the terms of service that, hey, don't rely on this. I'm not an artificial attorney or doctor or whatnot. There's some technicalities in the terms of service about specifically limitations of that liability, caps that are typically tied to the fees you've paid in the last 6 to 12 months, or a floor of $100, which I think, as most folks know, doesn't cover a whole lot of legal fees. Maybe it gets you a couple of really good minutes. The limitation of liability clauses and when they even come into effect, again, goes back to that divide between the terms. So usually you're only getting in some sort of indemnification, a situation where the company will step in and actually pay for the defense of the lawsuit that you may have received. It's usually limited to IP infringement. This is true largely across like the SaaS industry, and that's typically again on the enterprise levels. Once those terms change over, the free tier and the paid tiers don't typically trigger these obligations. They say, hey, this is as is. It's how we're sending it to you. We're not responsible. Um, this is a tricky area, and it's one of the things that I should remind folks. This is not a last mile type of service in most of these, especially with general AI, not something custom built for you and trained internally, but a chat bot that you're talking to. That is not a substitute for professional advice, and they try and say this pretty loudly in a lot of their terms.
Absolutely. Yeah. And so it sounds like there's kind of a cap uh, per kind of each. It's kind of what you've paid them is kind of the effective cap, right? So if
Yeah, and for free plans and the lower patrons, often they're just saying we're just not liable. Like don't even try and sue us. We've disclaimed liability here. You've pre-agreed that it's going to be $100, and then we're out of the picture. No matter sort of what we've done, and obviously there are limits of enforceability of some of this stuff in different states. Different states have different regulations about how much companies can kind of step out of the loop, but the I think the common understanding of law right now is yeah, they're putting all these disclaimers for you to sort of blindly trust, and follow the guidance of one of these AI generative outputs. It
Yep.
may not be the most reasonable reliance.
That makes sense. The short takeaway is don't ever count on uh, recouping any damages ever from something happening because of something AI told you to do or whatever. Treat it like this is 100% your responsibility. Treat it like it has errors. Treat it like it's wrong. Don't treat it like an authority.
Mhm.
That's, I think, from a practical standpoint, that's a really valuable takeaway. So this one's interesting. So do the terms stay the same or do they change?
And this is, and I think most of us have encountered this before and are becoming more familiar with it. But definitely the belief that the terms that you signed up with are the ones that are going to be continuing with you because that's what you signed up under, is very much not the case, especially under the free and base paid plans. Some of the enterprise terms, if they're giving you a static document and you are signing a signature at the end of it, which is extremely uncommon in SaaS platforms. Usually that's for some of the largest organizations getting a special side contract. Anything other than that, there's usually a line pretty high up at the top that says, hey, we can change these whenever we want in pretty much any capacity. We may give you notice, if we have the time to do so. We often won't. This is kind of the tenor of a lot of those terms. And keep in mind that this is also a constellation of documents. It's not typically one. It's a terms of service that governs kind of the core services and functions. There's a privacy policy that talks about where some of the data is being used for marketing purposes, internal training, and otherwise. There's an acceptable use policy governing what you should and shouldn't be doing with those services and the outputs of the AI. And then on the enterprise level, there's also a data protection agreement that talks about personal information and what they may be doing or not doing with that. So there's different documents that all may be updated independently. Often, if you look at them, they'll have different effective dates and times. They're updated on different cadences. So, I don't want to make everyone paranoid that every morning they need to wake up and check their terms of service. But it's good to keep in mind that, as with most contractual things, don't just do it once and then ignore it, for the next couple of years, right? It is a living, breathing document that should be looked at periodically. And there have been some big updates that can make significant changes, especially the default settings.
Yeah, and what are some of those terms that you've seen maybe change through the years, if anything?
We'll talk about some of them coming up. There's a couple of things just with how your data is used, what the default training sort of settings are. A lot of these go to, how your, especially if you're paying, if refunds will be given, what the service level that they're obligated to provide may be, how they may respond to claims of misuse or cancellation of accounts or retention of data. All of these things can be pretty important for a business, especially if you're starting to, build intelligence within the system, right? A lot of people are customizing these AI platforms to fit their business. If that data can live or die on you maybe inadvertently violating a small term and then they just delete your entire account and are not responsible for anything, all that time and energy may just evaporate. And if it's not able to be backed up, since a lot of these platforms don't offer like a download of that intelligence, these can have big ramifications for businesses that are starting to build this into their platform at a deep level.
Absolutely. Yeah. So and they'll typically send you some sort of an email or a notification when you open the app or something that tells you, hey, our privacy policy is updated or our agreements updated. And so yeah, important to take a look at those when those pop up, just so you know what's happening. I know, we're all
And I do recommend that folks kind of take a snapshot and download those if they can. It may help just to figure out, they won't often tell you what changed. So if you don't
right.
have the old thing, you don't, you're going to be reading through 100 pages to figure out like, wait, I can't quite remember. Is this different?
Yep.
Without that, it can be hard to parse them.
Absolutely. Yeah. And so don't count on the usage terms remaining the same. Um, and so let's talk about some details in these terms that surprise a lot of people. And so, this is a great topic. The difference between ownership and like usage rights. So,
Mhm.
talk about the difference between those things and what it means for small businesses or
Yeah,
mid-sized.
and this is a little bit similar to what I was talking about in intellectual property ownership. Ownership and usage is also can easily be sort of paired apart. You can own something, but license almost all of the rights to it, or in fact, really all of the useful rights to it to someone else, but still remain the owner. You don't necessarily have to sell it. Um, there's a similar function here that, again, when the platforms say you own it, we don't own anything, they may in the very next sentence say, but you grant us a perpetual worldwide unlimited license to do whatever we want with it. That would still give them pretty much everything you can get out of ownership,
Yeah.
especially if they give themselves the right to sublicense it or resell it, or who knows. Most of the platforms are not this aggressive, but you will see a distinction between the free tier and the paid tier where that changes. Usually the free tier, because again, you are the product there, they're giving themselves a much bigger license and usually using pretty vague language that could be interpreted a bunch of different ways. Is it clear whether they can put that into a product or sell it to third parties? Or, if you upload your face, is your face able to be put on something else? Like that kind of may fit within those free terms. You really have to be careful, especially on those lower tier plans, because that's where they may be seeking to monetize and sort of recoup what you're not paying for. The distinctions there can be pretty significant. In addition to this can be entirely separate from training the AI, right? This has been true before AI platforms, just before training was a process. People need to keep in mind that the training of the platform is one thing, and the usage of the inputs and outputs is another thing.
Absolutely. And yeah, I don't know if everyone has thought about the fact that if you're using a free version of ChatGPT, why are they offering a free version? It's because they have a way of monetizing you and monetizing the data and the information and the insights that you're giving it.
Mhm.
Probably in a number of ways that we know about and in ways we might not know about, right? And I think that making sure that you have a plan that is going to give you the protection you need, and they're not going to you can the more you pay, the less that you are the product, right?
And
um
again, a lot of people think narrowly about confidentiality or ownership in that, if you what you're putting in is not your own information, but your client's. And, if the client would be upset if what they gave you then popped out to another user somewhere else or was then monetized by that platform, which is probably most things, the ramifications may not just be, is this public or non-public? It may be, well, I'm the only one who should be doing something with that thing, right?
right.
There are other elements, especially for those of us, who have clients and are doing this on behalf of those clients or for their benefit, that you have to think about the ramifications up and down the chain with your own agreements.
That's really important. All right, next, the next surprise here. So, IP protection. And so, yeah, tell us about IP protection on these various plans.
Yeah, so this goes back to a little bit again what we mentioned at the outset about indemnification. Along with the very limited indemnification for intellectual property protection, there's one really big thing to keep in mind with most AI platforms is while for their own liability reasons, especially on the enterprise end, they don't want to be outputting Tweety Bird and Homer Simpson every time you type in something because that may upset some very large enterprises with a lot of big legal dollars behind them. The fundamental function of the AI is still something that was trained on a bunch of publicly available but otherwise protected information, and especially in the creative context where you're outputting images and videos and things that are highly likely to contain elements that you may not know are copyrighted by somebody else. That again, you're not going to be able to go back to the company that the AI company that gave you this and say, hey, you gave me this picture of Homer Simpson. I'd never seen Homer Simpson before. I didn't know that I was now printing him on a logo, and this is a big problem.
Yep.
But it's especially true at the lower levels where they're saying, hey, we've warned you, stuff may come out of this that's a problem, and that's on you to figure out. It's very hard to do that type of robust clearance and check every element within a piece of content to make sure that isn't owned by someone. We know a lot of big brands, but there's plenty of things that somebody somewhere owns that IP, and you may not recognize it right out of the gate. Especially when you're working with AI for these creative purposes, it goes back to the human input element that if you're over relying on the AI to give you most of the content, if that content's potentially infringing, that could have all sorts of downstream problems, including you giving that to your client and the client putting it out there into the marketplace, them getting sued, and then coming back to you to say, why did you give me this? And you're in the middle, having not known that it was toxic when it came out of the AI. This may not result in an infringement lawsuit, but there's plenty of cease and desist that will fly around that company may not sue you, but the cost of recalling those products, stopping those services, the PR kind of nightmare of all of those things, those can be very costly for a business. So keeping in mind that you not only don't have liability protection, but there is this element that you need to double check is really important as businesses sort of integrate this stuff and especially use it for marketing campaigns and creative production projects.
Yeah. And so what can people do? Because you mentioned, like images like Tweety Bird. What about just like the text that's coming out of it? And like, what would be a good rule of thumb? Because I mean, you could kind of say with anything like, well, anything that's coming out of these AIs is some sort of remix of some input, that was trained on. That input might be, intellectual property. What advice would you have for users to double check before they kind of run with something, and like what should they be double checking, if that makes sense?
Yeah, I mean, look, the easiest answer is double check anything that's coming out of your, like, just think about, have that in the back of your mind in the same way that you'd be concerned about anyone plagiarizing or copy and pasting something, or just grabbing something off of Google image search, or the things that have been true prior to AI that are still true now. There's a big element throughout the AI usage of kind of forgetting the lessons we've learned in the prior forms of the internet and other sort of open information systems. Keep those things in place. If you're getting content from a source that you yourself or whoever is the creative lead on your team did not themselves create, if it's not coming directly out of your brain, there should always be a little bit of a let's think about this a bit and make sure that it's original content, or that there isn't a clear tie to a competitor or another, especially in your own space. Like, most folks know what their competitors kind of look like or what they're doing, that if AI spits out something that seems like it's almost a copy of that, you should probably alter course a little bit.
That's smart. Yeah. So just use your critical thinking with these outputs, and double check before you just run with something that it's not going to come back as an IP infringement later. And So opt-ins and opt-outs. So this is really important. So this has to do with, are you, do you have to take the action to opt in order for AI to be training itself on your data, or do you have to opt out? And I think this is one area I think where the terms have changed over
Yeah.
time. And so tell us um, about what people should know about the opt in, opt out, and how they can protect themselves.
And this is a big example of what we were talking about before of terms changing and not being careful about that. So, in the initial sort of setup of these platforms, Claude was really differentiating itself by being a privacy forward platform and was kind of advertising, hey, we're not default training on your stuff like all the other guys are. Last year that changed. They did flip the switches to the other direction, to make things opt out versus opt in. That's one of those things that you need to be careful about, because that setting is often buried. And frankly, a lot of the UI around the settings of these platforms is not the most intuitive. There's, four different sections with different toggles and things you have to look into, scattered among, plugins and features and privacy. But you want to make sure that some of those really core elements like data training, data privacy, confidentiality, to the extent there's just a button that goes, one way or the other, every once in a while, as part of your, digital health check, go through your settings and make sure that those toggles haven't flipped. This is a big example of one of the platforms that people may have gone to specifically because they wanted this default privacy, and now that default has changed and they now have to opt out of it. So if they do nothing, they're now opting in essentially. It was a big example of kind of how, as things shift, that standard you're used to can shift out from under you.
Yeah, that's super important. Just like double checking what your settings are set to, and yeah, because and they, a lot of the times, with especially with these LLMs, whether it's ChatGPT or Claude or Gemini, they do seem to give you pretty minimal information, right,
Mhm.
about what control you have, about that, the terms have changed, about what they're doing with your data. And I'm sure that's one of their defense mechanisms, and, to provide the minimum required information to the user base so that they're legally protected and giving themselves enough latitude to kind of do what they want to do with your data. And it's like you said, it's such a frontier, it's such a new area
Yeah.
that they're kind of taking advantage of the fact that there really are no standards set yet. It's kind of all this is a period of time where they're really trying to have as much freedom as they can with their user base.
And not all of this is nefarious, right? A lot of this is, as to your point, is just leaving things to be flexible, because this is a very rapidly evolving area, and the core function of it is this kind of perpetual evolution in training models. So, as noted here, feedback and thumbs up and thumbs down on prompts, and when things get into sort of support chats, things get wonkier. It's not as clear of a you've opted in or opted out. There's separate clauses that talk about, well, you may have opted out, but when you give us feedback, that feedback is not only part of the training, it's actually owned by the company. That's a different, you're assigning over essentially a different class of information that is you are voluntarily giving to them. And that's to protect their own, service improvement, because if you owned it and they couldn't use it, then how does feedback really work, right? It makes sense in the functionality of what you're doing, but it may not be the thing you're thinking of while you're engaging in that process, right? So when you're
Yeah,
giving that feedback, if you're mixing together your own proprietary information and the feedback, then it's really hard. Like, they're not going to be parsing those two different things and separating them. So,
yep,
be careful when you're having support conversations that you're not putting your social security number in that support conversation, right? They're sort of health check things to think about that can get muddier in certain circumstances.
absolutely. And that kind of leads us into this next one, which is retention. So people I ask, can I delete information that I've given to them, or does ChatGPT remove, do they eventually get rid of my information? How long do they retain what I
Mm.
tell them? Is there anything to do about like deleting something or removing something from their database once I've given it to them?
And again, this is one of those things where there are a bunch of different types of data that are going to have sort of different versions of this, right? If you've opted into training, that's typically a one-way street. There isn't a way to extract training from the AI models. That's always kind of the most dangerous and permanent one-way type of opt-in. And for the platforms that have murkier terms about what is and isn't included in training, that's definitely something to keep a close eye on. Um, the most common set of terms is typically a 30-day retention tip, as a mix of both legal compliance. If you're searching, how do I build an explosive device, they're gonna maybe not want to immediately delete that if the authorities are kind of coming after it, in the same way that doing the Google search, that's been traditionally a point of tension for data retention of large platforms. But even just for accidental deletion or changing your service plan, if you close out one service plan, you want to start a new one 5 days later, you would probably want your information to port over rather than be fully destroyed. So some of these are for normal processes and conventions, but there are different platforms that have support data. Again, as we mentioned, has typically a longer cycle, if not an indefinite one. um, if you're really worried about a particularly sensitive piece of information, I mean, my base guidance is just don't put that in the AI unless it's a completely siloed on-prem solution. But if you have to think about some of these other things that, if for legal reasons or a dispute, you're trying to delete that off of the platform. This is a little more just an FYI that that deletion request may be active and adhered to, but there may be a tail of time just for normal processes, right? The same is true for most large platforms and networks. When you press delete, it usually sends a message to a server somewhere, and that server may not do that second, right? It may aggregate all those requests and do it at the end of the month to not burn resources. So there's always a bit of a lag, and there's going to be some unusual circumstances where that lag could be really important. And this is one of those things to think about. That time may have a gap to it.
Yeah, and so I think the important takeaway there is, just think twice before you give it any information that you might want to retract later, or redact or whatever in their
Mhm.
database, because you may not have the control. You may also not be able to even know if or when that data was deleted. um,
Yeah.
and so let's dive into the terms. This is, I think, really important for people. And as you mentioned, there are a lot of similarities between the terms. And as we've been talking about, the conventions are kind of being set as we speak, in terms of these different companies and how they're navigating these terms in the different tiers. So all these kind of rhyme with each other, but there are a few differences to be aware of. But yeah, kind of
Mhm.
walk us through these terms, and where they're the same and where some of them have some differences.
Yeah, and as you'll quickly notice, things have moved towards a common side, especially with sort of the big four here. There are plenty. Now there's hundreds of companies offering services both layered on top of these in the back end. Frankly, even so, I believe Microsoft disclosed that some of Microsoft's features are layered on some of these competitors' underlying systems as well. So even amongst these guys, they can kind of share resources, but this is true for these four, and they're the most sort of mature platforms. There's plenty of others where there is no enterprise tier, or they're completely silent on one of these verticals. That's something to pay particular attention to, because if at the lower level it's based off of ChatGPT, but the service you're using is utilizing the ChatGPT and then adding a bunch of other layers on top and maybe using your data in different ways, that may pose a further problem. The core takeaway here is what we've been talking about throughout, that the free plan, as you'll see, is bundled with the paid plans at the sort of the white lines here. So free, Go, Plus, and Pro for ChatGPT, those are all the same set of terms. You're paying quite a lot more money for like Pro 10x, but it's still the same basic core terms as free, and that means you have to opt out of training. The default is still going to be on for most of those. Um, there's no confidentiality. You may own your data, but everything you say in there presumably anyone at that company can access. It may kind of be spit out the other end to another user. Like there's no expectation of privacy in those chats. And that means that anything you type in there is very, very easily discoverable by any investigator or law enforcement that's looking for it. This is true in most circumstances, but especially so with literally no confidentiality terms. And a key element to remind folks of there, which we'll talk again a little bit further about later, is if you have confidentiality obligations to your clients, you need to ensure that the other downstream places you're interacting with also have confidentiality terms with you. So if you sign an agreement that says, I'm going to keep your information confidential and I will ensure that anyone else I hand it to also has those terms with me, and then you sign up for the plus plan of ChatGPT and put their stuff there, there's no confidentiality terms. You're immediately in breach of your client agreement. These things kind of float under the surface for a lot of folks. The same, there's no DPA. So the same, if you have a digital, data privacy agreement for all that digital information flowing back and forth with your client, and you're obligated to pass that down to the vendors you work with, that's not going to be present on these free plans or the lower tiered paid plans. The same liability caps that we were talking about, you'll see kind of the differences here. And again, the licenses in both the free and the paid plan, there's a much, much broader license. Once you get on enterprise, the terms subtly change and really lean into, sure, you'll give us a license, but only insofar as we need to do those things to give you the services. Like if you give me an image, I need the license to display that image back to you on my website. Like that's technically a thing you need to allow me to do. But I'm not going to do it for any internal purpose or external third-party purpose. That changes here on the enterprise levels, and the APIs are typically tied in. These tiers change every month or so, it seems. There's new ones added, things shift around, but generally what we've been seeing is that the enterprise and API side is the divide between the free and the paid plans.
That's super helpful. And maybe this is something too we can share with folks afterwards. They can because I think it's like a really helpful chart.
And as we've noted, and as I just said, this is likely going to be out of date in a matter of weeks. So please, you use this as a guide to post. But this has changed just since we've been developing this presentation.
That's actually a great point. We'll definitely timestamp this. But it is nice to, like you said, get kind of a broad strokes understanding of the kinds of tiers there are right now and what that means. And then as things evolve, you can kind of have a point of reference for like what's changing and things like that. But yeah, I think you explained this in a really useful way. So this is like my favorite part of the talk because this is some real tangible stuff. So where businesses get burned. So take us through this first one. You upload a contract to AI to help summarize it. Ooh. Why is that a problem?
So a lot of different things going on in this situation, and an extremely common situation more and more so these days, right? Be careful with confidential information. Typically, the contract itself and those terms there's a little confidentiality notice on the template of whoever's sending that to you. What you're putting into the blanks of that template is typically something that most businesses don't want to be shared. It includes their pricing information, maybe your address, the segments of service that people are looking for and you're providing. If that's being put into the free plan or even the very expensive paid plan that has no confidentiality, you may be in breach of confidentiality already. This is also very important for my clients. I really warn them, there has been case law on the use of AI, both, in this situation and another one we'll discuss in a moment, of, breaching attorney-client privilege, that if you're putting something that's, if I write a guidance piece and send it to you and then you put it in AI to double check it or think through it, you've sort of broadcast that out to the world and you've now opened the door that may not be protected anymore. If you're in a professional services class where you owe duties of confidentiality or you're promising them to your clients, be very careful about sanitizing things so that what you're putting in there doesn't need that protection, or that you're just aware and cognizant. You can get approvals or make disclosures to make sure you're aligned, but you just don't want to be navigating these things without paying attention to those details.
Yeah, that's really important. And it's worth mentioning too, that there really are ways around a lot of these things, right? Like you mentioned something interesting, like on-prem, totally offline processing, or just having, team or enterprise plans on Claude, or sanitizing the content. So it's not the message of this talk is not like necessarily, use AI, be scared of using AI or use AI even less, but it is to say that you have to be really thoughtful about these things in order to get the value that AI has. And I
Mhm.
would say if you're a business or a professional who's even cognizant of half the stuff we're talking about today, you're in a pretty top tier of awareness about these issues and navigating it. And so yeah, it's all about each particular use case. What are the risks? What's happening to the data? What are the usage agreements? And making really thoughtful decisions about each of those usage scenarios. And so the next one is another common one. So you use AI to create content, and I assume that could be anything. That could be a blog. That could be a something that could be an image. That could be content that's getting published somewhere, and then you just ship it as is. Seems easy and convenient. Why is that a problem?
So we talked about this a bit before in the intellectual property conversation. Again, without meaningful human creative contribution, that may not be copyright protectable. And that may not matter for some things, but it can create weird circumstances where, if you're doing marketing and your competitor can literally use the exact thing that you put out to also do their own marketing or make, sort of a riff on it, and it's not something that is also overlapping with like a trademark protection or some other thing that's creating a barrier, it can create weird circumstances. And this becomes especially important again where it may be spitting out something that's toxic that has someone else's IP in it. But it can also be very problematic if you're the creative vendor that was hired, right? If your client has hired you and maybe in their contract there is a subclause. Sometimes now we're seeing a lot more prohibition on AI use clauses going into vendor agreements or notification before AI is integrated into content. And many predating AI had an originality requirement. When I worked in house at Mattel, the creative vendors that we brought on, our clauses would typically say what you give us has to be original. If you're incorporating any third party IP or anything unoriginal, you have to let us know because again, that could poison the well of everything downstream of that IP. So that has been in play for quite a while. And if you're signing, some giant Fortune 500 agreement and that's buried somewhere in the IP clauses, you may not be thinking about, oh, just sort of porting this in is technically unoriginal, unprotectable content. I'm already in breach of my, massive, agreement with a large company that's really important to your business. Um, Thinking about the human creative contribution, reviewing the outputs and being careful about that, ensuring that you're, clear on your client obligations and any borderline issues that may cause problems are really essential to especially creative outputs with AI.
Yeah, that's really important. And like you said, understanding all of the contracts you have in place with your clients and all your other relationships in your business, um, that is essential for navigating this in a low risk way, and also avoiding big problems down the road, especially if it's a really important client. That stuff can be. I think part of what's interesting about this is it doesn't feel like a big deal when you're uploading a contract to Claude, or or whatever you're doing. It feels so easy. It feels so quick. It feels like probably your peers are doing the same thing. Um, but you are really exposing yourself to risks that will
Mhm.
become very apparent down the road.
And some may be reputational, some may be brand. It's not all, hey, you're going to get pulled into court over this, right? Some of it may be very practical. Is this going to be an uncomfortable conversation with a major client? Some of these things just have, more short run real world problems that, can impact your business in ways that, are not highly technical, but may just go, unthought of as you're kind of, working a busy life, right?
And actually, and here's a more positive spin on it as well, is being really competent around these issues when you're dealing with relationships and businesses and contracts that are saying, hey, we don't want you using AI for this. We want everything to be
Mhm.
original. we need confidentiality, all this stuff. If you as a professional are really competent and you can look them in the eye and say, oh yeah, here's how we handle that stuff. We understand that. And here's like, if you demonstrate competency around this issue, it actually becomes a really positive differentiator for you.
Exactly.
A lot of your peers probably are not very savvy around these things. And so I think that's a really important point that you brought up around all that. And so let's talk about this one. You rely on AI in an area that's not your expertise. And you sort of treat that like an authority in your life or your business.
Yeah. So, this goes to one of the key strengths of AI, right? It's a, much like the internet, it's a democratizer of information. It allows something to guide you through areas you don't know. It gives you the ability to start learning and researching and executing. People are vibe coding, apps and programs and software languages that they can't read or write themselves. That's fantastic, but you need to keep the grain of salt of, if it's outside of your area and you can't evaluate it, that's very high risk. Anything, I always tell folks to think of, especially with broad, chat AIs, they're your friend who reads a lot of stuff that, as you're having coffee, they're like, oh, here's a new thing that I read. You should kind of look into it. That's like the level of diligence I would recommend expecting from AI. And then everything above that is fantastic, but verify it, right? I tell my clients, there's a lot of useful information and it may help educate you on legal nuances that, hopefully it's giving you the right guidance, but don't end there. Like, start there, right? It's a casual conversation about these topics, then go to a professional to fine tune and refine and make sure it's the right fit for you. It's accurate, you can execute on it. At the end of the day, the current models are primarily predictive models. They're not logic and reasoning models, right? They're evolving to have sort of layers of applying that in enough iterations that it has more of the feel of being able to sort of self-assess, but that's not their core function. So the more you're leaning into areas that you don't know and asking for things that are not AI strengths, like really substantive reasoning and strategy, you're going to be going farther and farther afield, and you really need a human in the loop who can evaluate the output that's coming to you. That's such a key element now as people are expanding and using this to sort of conquer new territories. Always make sure that you're smarter than the AI. Otherwise, you should probably bring in another smart person.
100%. And I think we've all had that experience, because AI will, no matter what it tells you, it will tell it to you with complete confidence.
With confidence.
And that confidence is very deceiving, because you're like, well, this thing is so confident, like it must know what it's talking about. But as we all know, you can actually kind of spin it. You can change its opinion really fast by kind of pushing back and things like that. I think I've always said one of the biggest breakthroughs for AI is going to be the day that it knows how to say, I don't know. That's a good question. I don't really know. I'm not an expert. It's never going to say that, at least not yet. And so you have to take it with a grain of salt. I think the analogy of, hey, this is my friend who knows a lot. He knows a good amount about a lot of things, and he's telling me about everything. I think that's a really good kind of litmus test for like, how much am I going to trust this information. And I want to leave a few minutes for Q&A. So let's kind of we have one more here. Which is something that we probably all or most of us have done. You're recording a client call with an AI note taker. Talk about the risks around that and the considerations for professionals.
So the first major thing, California, especially in many states, two-party consent state. So you surreptitiously recording other people itself is a violation of the law. So it's part of the reason why most of the Zooms and different types of remote video conferencing software have like a banner that pops up saying, hey, you're being recorded. It's to kind of help facilitate so that they're not sort of an accomplice in surreptitious recording. But keep this in mind. This is obviously, in public places, this is different, but in private meetings, make sure that everyone's on the same page and agreeing, so that you're not sort of inadvertently tripping over a legal requirement to disclose that it's being recorded. Another thing to keep in mind, again, is confidentiality. If the system that you're using doesn't have a confidentiality section in its terms of service, That's really dangerous for recordings. You're basically creating, and these are not always accurate. So keep in mind that if it's not protectable and people can look at it, and it may not even be accurate, you could be setting up a false record of the thing you're talking about and have it be discoverable in pretty much every format by law enforcement, by opposing counsel in dispute. Who knows? This is especially important. I tell my clients, do not use AI recording when having conversations with me. It's not the latest case law on this is that it is not protected by attorney-client privilege unless it is controlled entirely or at the direction of the attorney. Even if I'm aware of it, I have to be the one turning it on to be confident that it's going to be protected and shielded from discovery. Otherwise, the conversation we have about the things you should and shouldn't do legally may be something that the person suing you gets to grab in discovery and then say, hey, look, you asked, should I do this? The attorney said no, and you did it anyways. That's not going to look great, right? And the same is true for any highly confidential conversation. I'd recommend generally to not use the recorders for that, as convenient as they may be. You may be creating a problematic record that could come back to bite you.
That's such an important one. And I'm going to move to our last slide here, which is 5 questions to ask before you use an AI tool. So take us through these real quick, and then we can also hang for a few extra minutes for Q&A, depending.
Yeah, happy to stay late with folks. So this is what we've been talking about throughout, right? So, you should always just be kind of keeping these in mind as you're implementing these tools, evaluating them, looking at the terms. Privacy. Is there substantive terms and clarity around whether or not they're training on your information? Is there confidentiality? If you're putting in something that you have an obligation, whether it's, HIPAA and medical health privacy information that's essential to your business or something else, is there a DPA that you're obligated to get with any vendor that is lacking here or present or only on the enterprise tier? Or is it just nice marketing language that says, hey, we're privacy first, but then you never hear about it again, which is all too common these days. Transparency, is the use that you're using this for at odds with your client obligations or disclosures? Or would your clients be very surprised to find that this was involved in some way and very upset about it? That, I always tell my clients, upset people are your biggest liability. Anyone can sue anyone for anything. It takes a lot of money to prove you were completely in the right and everything was fine. If there's something that is going to be a potential, reputational disaster or really inflame anger with folks, be careful about that. Ownership, again, do you need to have ownership? Do you need to have IP protection? Are you clear on what the terms of that are? Are you on the free plan where, sure, you may get an output, but maybe they also get to use the output, or somebody else gets to use the output, or it's shared as part of a, kind of community output? Those things can be very important with certain, sets of services. Back to our expertise point, is the AI operating in an area that you have no grounding? Be very careful in that. It can expose you to different types of liability. You could be kind of holding yourself out as an expert in something that you're not. It can be just guiding you and your clients in the wrong direction. I think those we intuitively understand are big problems, but can be very enticing. Again, Rob, to your point, with just the confidence, the unabashed confidence that most of these AIs have. And then in the very next turn, they'll say, you know what, I was totally wrong. Here's the right answer. And that right answer is also still completely wrong. I can't tell you how many non-existent products I've been recommended as the top 10 dishwashers on sale or something.
Yeah.
And lastly, again, oversight, the practical execution of this, how are you going to manage and maintain, check the settings, the terms of services, how your employees are using them, that they're all on enterprise plans or your account plan, that you control the data. We're seeing a lot of organizations running into the same problems they ran into when cloud storage and Gmail first came on the scene, that people are using personal accounts rather than company accounts, that there's no access controls because some of these systems and platforms are very new and they just haven't built that out yet. Those are all risk factors we've all dealt with before that we need to keep in mind are still very, very true here, if not more so.
That was really excellent. Hey, Andrew, this was really informative, so important. We're going to have this recording available to people, and we are going to share clips and things like that as well. I want to leave a few minutes for Q&A. Does anyone have questions for Andrew about anything we talked about today or something else? Just drop it right in the chat. And if not,
yeah, just type in the chat. We should be able to see.
Yeah, we'll just wait for a minute or two. But yeah, I think that for me personally, thinking about the role of AI in terms of, not taking that output with putting a ton of authority with the AI and saying this thing is, I've always said as well, kind of echo what you said, like treat AI like an entry level, very confident intern. And then a lot of people treat AI like an authority, like you're saying, oh, this is like like an attorney or a marketing professional. And don't get me wrong, there's a ton of value with the outputs it gives, but again, you have to do not outsource your intuition to the AI, right? I think that's another good way to put it, is make sure you have the intuition at the end of the day. Don't go, oh, well, I was feeling this way, but the AI feels this other way. So I'm gonna second guess my intuition, even though I'm the expert, or this is my business. And we do have like a question here. So great webinar, guys. Is there a way to mask details, private info when uploading documents to an AI platform?
I'm not aware of a way to mask that. I mean, frankly, it would be, in my mind, just removing it entirely, putting it into something where you can fully I hate to use the word redact these days, because also in the legal universe, the covering something over, so you can't see it, may not actually be removing it from the back end data. And AI is, often good at looking at things in ways that, we as the user may not, right?
Yeah.
I would make sure that what you're typing in, and if you're uploading a document, that there isn't a versioning in it that it can sort of roll back whatever you just did. Make sure that what you're putting in is already clean, right?
Right.
And it's, you can't really say, oh, forget what I just told you, or delete that, right?
Yeah.
The way these systems function, it's, the chat records, the data retention, and the history is pretty murky. The UI is very different across them. I would never rely on being able to sort of go back and remove or clean things.
Well, and I've got an answer to this one. Speaking from the technical side, there actually are tools for this. So there's something called an anonymizer, and what an anonymizer does is it is actually something that does exactly this. It'll take your data, it'll take a document that's filled with information that you don't want, and what you can do is it'll replace important information with fake information. So fake social security number, fake address, fake name, whatever you want, fake phone number. So it stands between the document and the AI. And then when it comes back, it'll reinterpret it back, and this can all be done on-prem, so that stuff is not touching the computer. So there is an interesting solution. It's a bit technical to set up, but it's definitely something that, if you're interested, Future Foundations can help put that kind of thing in place as well. So it's kind of a great solution, because what you want is all the reasoning and processing power of the LLM, but you don't want you don't want it to ever touch the real information. And the cool thing is you can kind of just process it all, fake information, reinterpret it back on the back end, and kind of get the best of both worlds with that. So.
And keep in mind that there's levels, right? That, when you're operating within an enterprise system, the document itself, the information that's in it, there's different classes, and both may need to be protected. So if you're parsing it outside of the enterprise network, maybe the document, even sanitized, itself shouldn't be put in a non-confidential area, right? So it's important to think that there's multiple layers to private info.
Absolutely. That was a great question. If we don't have any other questions, again, I'm Rob Wiltsey with Future Foundations. If any of you would like, anyone who's on this webinar, happy to offer what I call a free AI assessment, which is basically just looking at your entire business and just making a recommendation. Hey, I would use AI here. Here's some technology you may or may not have been aware of. I would kind of avoid it here for different reasons, and all that sort of thing. And then Andrew, anything you want to leave our audience with?
Feel free to, I don't charge for my initial consult. So, if you're not sure whether I can help, I can almost guarantee there is some way that I can help your business, as most businesses just don't have somebody like me to bounce things off of. Don't wait until you're, having hundreds of employees and getting sued for things and doing, many contracts every month without any legal oversight. Please feel free to reach out, and, I can at least point you in the right direction, at a reasonable limit without, any big commitment.
Awesome. Well, thank you so much, everybody. Thank you, Andrew. This was really, really valuable. And we will be doing more webinars in the future. So keep in touch.
Thank you.